And if you can acquire those equitable interests that may be out there through use of a quitclaim deed or other type of conveyance, that's going to be preferred to bringing an adverse possession action. Then the other kind of equitable action, it is a foreclosure action in the event that somebody didn't pay back the money that they were supposed to pay back and there's a security interest on the property. The judge is going to issue an order that is going to allow the lender to come back in and take title to that property. The next type of ownership that is less than that full bundle of rights is a life estate. A life estate vests a fee simple title in the owner of property for his or her lifetime. At his death, generally there is a remainderman specified. It'll say, I want to convey this to my child and reserve a life estate, or I can say that I want to purchase a life estate. I can do all kinds of things and acquire a life estate and property. I can get that by will. If my husband dies and says, I want to leave this property to my wife for the term of her natural life and at her death to our children, then I have a life estate in the property. It's been created by the will of another. So the person who has the life estate is the person who is entitled to use the property and benefit from the property during his or her lifetime. And the people who are entitled to get it at the time of the life tenant's death are called remaindermen. If there are no remaindermen named, then the property reverts back to the grantor and goes through his or her heirs. Sample language here: to John Doe for the term of his natural life, and then to Jane Doe. John Doe is the life tenant, Jane Doe is the remainderman. There are some problems with having a life estate. One is, who's going to pay for the maintenance and upkeep and property taxes on the property? Who is going to make sure that the roof is repaired? Who is going to make sure that that the timber is harvested in a timely manner? Who is going to benefit from the timber sale? All of those issues have to be resolved between the life tenant and the remainderman. Life estates can be retained or they can be conveyed, as I said before. And the next type of property interest is a defeasible title. A defeasible title is one that can be taken back because of the occurrence or non-occurrence of some event in the future. There's a reversionary interest that can be created by saying, I want to convey this to, let's say, I want to convey the slave market in downtown Charleston to the city of Charleston, so long as it's used as an open air market for the public. But if it ever ceases to be used as an open air market for the public, then it reverts to me. Real life case. Okay? And it has to be open 364 days per year. Right now, the Forestry Commission is dealing with fire towers that were often conveyed with this provision. That there is a reversion of title built in if it's no longer used as a fire tower. And we've done away with the fire tower system here. So lots of that property is now either reverting back or the state's having to buy out the heirs. There is also a defeasible title called re-entry on condition subsequent. It's similar, but with the reversion is automatic upon the current occurrence of some event. With the re-entry on condition subsequent, the owner says, I'm going to give it to you so long as it's used as a fire tower, but if it ever ceases to be used as a fire tower, then I reserve the right to come in and claim it again. So I have to do something to get it back. With the reversion, it's automatic. You don't have to go in and do something to get it back. Then there are non-freehold estates. These are much less than the bundle of rights. Leases. If you live in an apartment, you have a non-freehold estate. You have a lease. You have the right to use the apartment for certain things for a certain period of time under certain conditions. You can lease land as well. Generally, they're long-term leases. And there are places in England, for example, where there is no freehold estate. All of it's leased land. You have 99-year leases that are renewable. Around some resort properties like Santee Cooper, those were leases of those lots that may have been converted at some point or may not have been. Easements, the right to use a portion of your property for some particular purpose, like power lines. You have given a utility easement, every one of you who owns any property, to some utility company to run a power line across your property. And you give them the right to come in and maintain those lines. So if those lines are underground and you've planted bushes on them, nice little pretty bushes that bloom so well and you love them, and they come in and they dig them all up, they're in the easement. You gave them the right to do that. A license is similar to an easement. If you gave somebody the authority to erect a billboard, for example, that would be a license for a specific purpose for a specific time. Restrictive covenants is something that most people are familiar with that live in subdivisions, and they can be a nightmare. They are intended to benefit the common good. We always have questions about who enforces them and what they really mean. Usually they involve setback lines, they involve uses of property. They don't want you to park your boat there overnight. They can get real petty, but restrictive covenants are generally in place to benefit a neighborhood or a subdivision as a whole for the greater good of the residents. Leases, of course, are non-possessory estates, generally lasting for a term of years. Easements granted by reservation and deed, or they can be acquired by implication because they're necessary. If somebody has driven across your land for the last 30 years to do something, he may have created an easement that he can enforce by going to court. And if you have conveyed a portion of your property and you haven't given that person access from a public road, there's an automatic easement that goes along with that to travel across your property to get to that end holding. So consider that. If you have that situation, you might just want to memorialize with the person who is driving across your property for something that you are giving them permission to do so, and just memorialize it in that way. Make clear that it was not your intention to create an easement by necessity or by use. Restrictive covenants, of course, are covenants that benefit a particular group of landowners. Very often, all of these interests run with the land, meaning that when you convey it to another owner, those uses go with it. They're prior in title. We have notice of them because they're generally recorded or because there's a use established there. If you have a legal question about real estate, please go see an attorney. Please do not take your neighbor's advice or the wisdom of your uncle-in-law about what this means. It differs from state to state, but in South Carolina, the interpretation or creation of documents affecting title is the practice of law. You have to have an attorney present to have a closing, to sign a deed, to sign a mortgage, to do anything at all that is necessary to affect ownership in your property. Please seek the assistance of an experienced real estate attorney, and you're going to hear me say this several times during this presentation. There are lots of us attorneys out there who want to be able to tell you we know everything. And when you come to see us, we're going to say, oh, that's a good question. I'll get back to you. Well, what we really need to be saying is that's not an area I practice in, and I really need to either associate somebody who knows what they're doing, or I need to refer you to somebody who knows what they're doing. And sometimes, as clients, it is us who needs to say to them, is this something that you do? Do you know how to do this? The very first thing I did when I started private practice was a conservation easement. And I learned an awful lot, but it was because I associated somebody else to help me with it rather than trying to figure it out on my own. So if you need the assistance of an attorney with an issue affecting the ownership to your property, please see an attorney that is a real estate attorney who is familiar with real estate issues. Now, the next thing that we're going to talk about is how you own your property. You may own it, just you. It may be in your name only. And if it is, it's your property, you own it individually. You may own it with another person as a tenancy in common. And in South Carolina, as in many other states, I suspect, if you own it in common with another person, and it doesn't say it's with rights of survivorship, each of you owns 50% of it.